the questions I ask you to go through. Does it inspire you? Does it convince you? Does it
confuse?
It confuses. Why? Yeah.
Well, because I don't know which position to take. Because confusing in that sense that I can see some reasoning, but I also cannot. I'm also on the side of the women.
Applicant, yes.
So it's confusing. I still don't know
which side to take.
Yeah.
Okay. Anyone else?
Well, I was also confused because I thought that it's gonna be the violation on that basis. But that is the problem with choice. You need to go really deeply into the personality and only that person to know if that is a choice or that is not a choice. But I thought because it was such a broad thing that, and also how it was positioned in the whole case, it was just, should be, the violation should be.
Okay, let's, we'll come to that issue, whether there should be a violation, but it's not just whether there should be a violation or not. It's also the question how it is reasoned. So it's not, we can, for example, agree that there is no violation, but then did really court reason it in the best possible way? Did it really stick to its previous case law, for example?
But I would say that regarding the violation, I would say violation for the freedom of religion, thought and relations for that. So I can understand why the others are very
we're focusing on that aspect of the interconnection between Article 9 and 14 of the Convention in this case. Okay, I'll slowly introduce you into the topic. If this computer allows me. So I find it to be a hard case, actually. So there is this distinction between easy cases and hard cases. And hard cases being those cases where we don't really know how to, we're not very much sure, we're not 100% sure. And this is why it's very, very much important to find appropriate reason to justify it in the right way. And I also advise you to take a look at the dissenting opinions. I don't know if you have taken a look at them. So I told, I'm sorry, I maybe didn't tell you, or I did. I have so many classes also in English in the other master of European integration. So the European Court of Human Rights has that opportunity to the judges of the court who disagree with the judgment on the merits, they can write a dissenting opinion. And that's a very good thing because then they can say why they think that, for example, if this is no violation, they can say why there is a violation. And also they can write concurring opinions. For example, they can say, yes, I agree, this is no violation, but it should have been argued differently. The arguments you put are not correct. Because it's important to know why we argued one way or another, because, we may not be on the same page with the arguments, you may think that it is unconstitutional or unconventional for one reason, and someone else can think it is against the convention, non-convention, or violation of the convention, or not violation of the convention for another reason. So the beauty of the European Court of Human Rights is the fact that the judges have this opportunity. And why is this the beauty? Well, it actually sharpens their thoughts. It sharpens their arguments because the majority knows that they have to really provide convincing arguments, because on the other side there will be dissenting judges, dissenting opinions, who will refute them. So they have to. It's quite mutually stimulating, this fact that they can have dissenting and concurring opinions. So I advise you to look at the dissenting opinions in this case. They're very convincing. this is, why is this a hard case? Well, because there has been a series of administrative and judicial cases on the wearing of the hijab in education institutions and workplaces in France, Germany, Switzerland, and Turkey. The conflicts over wearing burqas and niqabs in public places have arisen as major political and even constitutional issues in France, Belgium, Italy, Norway, and Switzerland. Here we have a case of a French anti-burqa law, and there are further developments such as the entrenchment in the Swiss constitution of the anti-burqa provision. So that's not totally new development. This has been the case for the past 2 years, and soon. They have introduced this anti-burqa, the prohibition by burqa, even in the constitution in Switzerland, but it has not been applied yet, as far as I know, because I think there is still the time has not run out for the legislator to adopt the implementing law. So it's in the constitution, but the legislator has to adopt an implementing legislation. So I don't think it has been adopted yet. So this is you understand, this is it's a controversial issue. It started as an issue in France, but it has been going on for a while in other countries. I'll give some examples, so I will not mention them now, but it was primarily the issue of wearing of burqas for girls in schools, but also for teachers. Okay, so the question was whether a teacher, I mentioned last time, Dala versus Switzerland, and there will be, as you'll see, Leyla Shaheen versus Turkey for university students, and there was also Kirvanji and others versus France for high school students, whereas Dala versus Switzerland was the question of a maternal school teacher, whether she was allowed to wear burqa or not. There are other issues in Germany as well, and there are also some judgments of the European Court of Justice, the Court of Justice of the European Union in Luxembourg on this issue. So this has become a very important issue. As I said, with these administrative and judicial decisions, but it has been beyond that a very important political issue, a question over which political parties clash. The issues of identity, Christian identity of Europe is regularly raised. And this has been particularly a problem in France and Belgium, but also, as you saw, in Switzerland, and also in Italy and Norway. There will be occasions to give some more examples. Now, let's be clear about the terminology. Hijab is just a headscarf, okay, tied under chin. Burqa is a full body covering, including a mesh over face. Niqab is a full face veil, leaving an opening only for the eyes. So that's little. Burqa has a mesh, and at niqab there is no niqab. The niqab doesn't have it. There are also other terms like chador they use as well in Afghanistan, in Turkey, etc. And there is also a new thing, burkini, combination of burqas and bikinis. So we came to the full body suits, burkinis, and the issues of burkinis, for example, have been present in France and Italy.
Local level.
It's true, because actually the Muslim religious community in Bosnia is very much under the influence of Saudi version of Islam, and not under the influence of the Turkish version, which is very interesting. So they have been under this pressure in terms of body wear. Basically, in France, for example, you have a very strict. It may look, I don't know, maybe in some other European countries, I've seen it in France and I've read about it, and in Italy as well. But in France, there are very strict rules on how people can be dressed up in swimming pool. Like also men, like shorts are not acceptable. If it is if it is not a slip, it has to be a very tight swimming trunk. It cannot be a short. Right? They will not let you in. They will take you out of the water. And so I haven't inquired actually where it really comes from. I have impression it comes actually from the need to not discriminate women, and because the point was to obviously forbid burkinis, to forbid for women to wear basically to wear suits, because you have situations where women really go to the water in the suits. And this doesn't apply as a ban just for the swimming pool, it also applies for the public beaches in France.
I don't see where there's a problem. I went to holiday to Tunisia.
Yes.
And I was in a swimming pool with women in totally normal. Tell me if it's my problem when someone else is wearing.
Yeah, I mean, it becomes particularly weird when you have these administrative bans, which then, theoretically, hypothetically brings to a situation where you can, maybe if someone really wants to implement that ban, then the person can invite police and ask, for the policeman to undress the woman, because she's too much dressed. It's really very, very ridiculous.
I understand in a school or like a teacher giving an example.
Yeah.
It's really.
Yeah, it's very. It's like that. So so there are. I can't really explain. There are 2-3 versions of the swimming suits that women can wear, and 2-3 versions of the swimming suits that men can wear. I'm sure that these rules for men were introduced in order not to discriminate women. Like it applies not just to women in these restrictions, but also to men. Okay, so this is just to show you how really it can become strange. Let's use that sophisticated term. And it's an introduction into this more serious topic of burqas. Now, let's just go back to what we were talking 2 weeks ago, when the topic was freedom of thought, conscience, and religion. And there are basically, for every article of the European Convention, generally there are 1, 2, 3 major landmark cases. Like the whole case law started from that case. And this is the issue with Kokkinakis versus Greece. I mentioned it yesterday. The paragraph says, the judgment says, as enshrined in Article 9, freedom of thought, conscience, and religion is one of the foundations of a democratic society within the meaning of the Convention. It is, in its religious dimension, one of the most vital elements that go to make up the identity of believers and their conception of life. The pluralism indissociable from a democratic society, which has dearly gone over the centuries, depending. So this is a religious belonging, religious feelings are very important for the believers. They make part of their identity, and that has to be taken into account. Like our European societies have become, or are becoming, well, it looked like at some point they're becoming very secularized, and then you can see what I mentioned, the clash of civilizations. There is a strike back of the of religious feelings and religious identity. So this has to be taken into account. This is why this freedom of thought, conscience, and religion is present in all regional and global conventions. I mentioned that was actually one of the first, if not the first, internationally recognized human right. freedom of religion. And then the court also said, while religious freedom is primarily a matter of individual conscience, it also applies inter alia freedom to manifest one's religion. So not just that it is a matter of one's identity, but the question is, what does that imply, and where does it lead us to? Well, this leads and this implies a right to manifest one's religion. That's explicitly stated in Article 9, Paragraph 1 of the Convention. Bearing witness in words and deeds is bound up with the existence of religious convictions. And then it's always good to take a look at the general commentary of Article 18 of the International Covenant on Civil and Political Rights. That is the general comment number 22. Bless you. It says the observance and practice of religion. We notice that the observance and practice is one of those terms which are defined. May include not only ceremonial acts, but also such customs as the observance of dietary regulations, the wearing of distinctive clothing or head coverings, participation in rituals associated with certain stages of life, and the use of a particular language customarily spoken by a group. So the wearing of distinctive clothing or head coverings is something which is indissociable from the freedom of religion, freedom to manifest one's religion. Okay, this is a way of showing observance, manifesting observance, or practicing religion. And one of those cases which was, let's say, for a very long time, the leading case in this field is Leyla Shahin versus Turkey. As I said, it is a case of a student of a Turkish university, of Istanbul University. She wanted to wear a headscarf. She was punished for wearing a headscarf, like hijab. And the court found that there was no violation, that she was punished for wearing a headscarf. The court has frequently emphasized its state's role as the neutral and impartial organizer of the exercise of various religions, as well as that the state's duty of neutrality and impartiality is incompatible with any power of the state's part to assess the ways in which those beliefs are exercised. So the state has to stay neutral in that respect and should organize, in other words, for a possibility for various religions to be able to be practiced, to be exercised. Okay, and we come to Article 9. Once again, we see that everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief. Okay, we said this is forum internum, and freedom either alone or in community with others, and in public or private, to manifest his religion, her religion or belief, in worship, teaching, practice, and observance. Okay, so and we see that Article 9 recognizes this way of manifesting religion, practice, and observance. And that practice of and observance is that wearing of clothing, religious clothing, is a way of practicing and observing. And then we come back to, now the question is put, when the state punishes someone, limits someone's right, to see whether that limitation was in accordance with the convention. So some limitations are okay, some are not. What is the standard? Freedom to manifest one's religion or belief shall be subject only to such limitations as are prescribed by law, so legality, and necessary in democratic society, proportionality, in other words, in the interests of public safety, for the protection of public order, health, and morals, or for the protection of the rights and freedoms of others. So these are the legitimate aims, and what is relevant for us is to look at these legitimate aims, public safety, as a legitimate aim of potentially as a reason for limiting someone's right to wear a headscarf, or burqa or niqab. or eventually the protection of rights and freedoms of others. Okay, what would be the public safety argument to forbid someone to wear burqa or niqab in public?
Are in the country,
you're hiding, yeah? If you're hiding from the... Okay. Any other public safety arguments? Well, if you want to commit a crime, it's a good to disguise, yeah? For example.
But I could also...
Just remind your name?
Martin.
Martin, yeah.
But I could also wear a corona mask.
Yes.
So,
You could have
a corona mask.
a corona mask, yes.
So, pointless.
Yes, except that burqa and niqab, they cover your body as well. Your body is fully covered, and your face is fully covered.
Yeah. And I could wear a rain jacket, rain trousers. I can easily pull off. Same results.
Same result.
Yes. Okay, it's true. It's true. But then at some places, yeah. Do you think that we should, however, take off masks and take off jackets?
No.
No. When we travel, for example, and we pass the security controls at the airports.
I think that there have to be a solution in order line privilege. And there are solutions, and there's no reason for that to ban it, because there can be found other solutions which respect the religion more.
Okay, you think it should be adapted to when it is for the religious reason. Okay, good. And protection of the rights and freedoms of others. What would be an argument to consider legitimate to limit to forbid burqa or niqab for the protection of the rights and freedoms of others?
Only if some criminal act. That is the only, but that also goes in hand what with the obligatory masks and whatever, or scarves when it's cold. So we cannot only ban this, then we follow this law. So only if there is a criminal act happening, if somebody is murdering someone, and that is only taken.
Yeah, but here you, what's your name? Sorry. Myla, yes. Just a second. Here we are talking of situations where you are preventively someone, like you're introducing this as a ban, as a rule. And if the moment you see someone, the policeman, the moment someone sees someone wearing a burqa or niqab, in those countries in which it has been banned, for example, in France, in Belgium, it has been banned in Belgium as well. In Belgium also, yeah. And as you could see, Switzerland has introduced the ban as well. So that implies automatically a penalty, and even maybe a criminal investigation. We'll see. So here it's not, if someone is trying to rob or kill someone, that's a far more serious problem than very. Yeah. Okay. Okay. So for the moment, you don't have any idea why it could be problematic from the perspective of the protection of rights and freedoms of others. Yeah. Sorry, my bad. Yes. I keep that. Yes.
Yeah. In school,
yes,
as a teacher, because it could influence kids.
Yeah.
And this would interfere with their freedom of religion, because they don't choose not to have religion, and it could influence them. So maybe It's really, really far away because as a teacher it makes more sense because you have actually influence on the children, but if somebody is like this in public, it could influence somebody's right to believe in nothing. It's a really, really bad argument. But what about CrossFit? Yeah, it's the same thing as well. And also, maybe I should know, in courtrooms in Germany,
yes, there are crosses in the courtroom.
Jump on the allowed.
Yes.
I never see that, like, I don't know if it's true, maybe you know, that in Germany it is forbidden to build minarets.
Yeah, the mosques, the spikes of the mosque.
Do you have them or? I heard that it's forbidden.
In Switzerland, it's forbidden.
Yeah, and I think it's because of the height of the other building, so everything needs to be like in a tandem. So, I don't know.
Yeah, it's interesting, yeah.
I said at the beginning, for the choice feminine, the headscarves and forbidding them, it can go, if you are not wearing it physically, and then you have some things that is kind of, giving you the right to do it, not because you want it, but because the law stands on it. But that is also not the biggest line, because that is maybe good for a part of the community, but part will suffer and be confined to houses because they cannot go outside because they will be secured because they are living.
Yeah, thank you, Dushka. We will further on, this is very good, we'll develop further on this argument. But just to show you how things are unfortunately not quite consistent in the case law of the European Court of Human Rights. I mean, generally we consider it to be a very good court, and the case law it has produced has been very rich and very consistent. But, for example, Dalab versus Switzerland, the case of a maternal elementary school teacher who was wearing headscarf, hijab, and the firing of that teacher was not a violation of the convention. So the court found it was okay. It was Switzerland is a secular state, and there is this public duty of neutrality in the context of a secular state. What court has previously said in the Leila Shaki. But, for example, when the case of crosses, I mentioned that 2 days ago in another case versus Italy, which is Lauzzi, when that issue was raised, the question of crosses in Italian public schools, the chamber found that there was a violation, that the crosses were not in line with the convention. And then there was a request for the Grand Chamber to decide, so for the, let's say, appeal level of the European Court of Human Rights to decide. And then, as I mentioned to you in the last class, then all the churches and religious organizations, they mobilized. And they made a very heavy pressure on the judges, including, as I said, some American organizations. They joined in as third-party interveners. Even some first instance chamber judges who by definition cannot sit on a grand chamber, so they're not, because there is a separation of the two levels. They were basically, so to say, blacklisted. They were targeted by some of these organizations because of the chamber judgment that Lauzzi, that crosses were not acceptable from the point of view of the convention. And then the Grand Chamber said that it was in line with the convention. What was interesting is that the European Court of Human Rights accepted in its reasoning it borrowed basically the reasoning from the Italian Court of Cassation, because of course it looks into the judgments of the domestic courts and how they reason their views. And the Court of Cassation said, well, those scenes of crosses and crucifixion, they're not just religious symbols. They transpire the original religious value and the symbolism, and they have reached the level where they can be seen as scenes supporting love, tolerance, peace, sacrifice, so general values. Sorry? So it has become it basically gave a secularized version, explanation of what the crosses are. So what was interesting for me is that no one asked the European Court of Human Rights did not bother to ask the Italian authorities for just one simple explanation whether the students were given that kind of explanation. Because, to have one hijab teacher, okay, maybe if there was no dalab, maybe there would be more hijab. Very hijab, But this is a symbol, it is an object present in every room. It is everywhere, and the most obvious meaning is religious. Okay, maybe it has other meanings, but the question is whether anyone has offered students, pupils, that kind of explanation, so that they can understand that this is not a promotion of the Catholic religion or Christian religion, but actually a symbol of peace and love. Dushanka, wanted to add something?
Maybe just for clarification, but I think that you actually... No, that's fine.
Okay. So let's go further into this case, and let's look at the French law, which was adopted in 2010. It says, no one may in public places wear clothing that is designed to conceal the face. For the purposes of Section 1, public places comprise the public highway and places open to the public or assigned to the public service. The prohibition provided for in Section 1 shall not apply if the clothing is prescribed for or authorized by primary or secondary legislation, if it is justified for health or occupational reasons, or it is worn in the context of sports, festivities, or artistic or traditional events. So it has to be some kind of event to wear it, not be like going to the doctor or to the grocery.
So it's like a costume.
Yeah, it is allowed to be worn as a costume in some events. I mean, not burqa or any other way of concealing faces. Yeah. Any breach of the prohibition laid down in Section 1 shall be punishable by a fine at the rate applying to second-class petty offences, and an obligation to follow a citizenship course as provided at paragraph 8 of Article of the Criminal Code may be imposed in addition to or instead of the payment of a fine. Okay, so you see that this is quite broad. The prohibition, it's everywhere in the public places, and it is without specifying, without how should I say, without designating it as a religious thing. So, and looking from a distance, it may appear as a neutral provision.
I'm just wondering what's the reasoning behind that, but like the hidden one. Are they want them to go and move from a country? Because from the perspective of that person, you have only two choices. You cannot live there, you can move, or you need to resign your religion.
To recount your
So it puts you in a shakmat position.
Yeah, that's a very good question, Jan. I don't know if you can take a deeper look into the judgment, and you can see that the documentation for the law was quite important, voluminous, and there you could find as well, like that at that moment there was no more than 1,000, so less than 1,000 women wearing it in whole France, comprising of more than 60 million population. The question is really, what was the problem? Why was that needed? Yes, I mean, there are these, as they call it in France, mouvements identitaires. From time to time, these movements, these, political parties, high figures, journalists, opposition, some other intellectuals raising the question. Well, you have the famous book, Mission, Submission. Okay, so I'm tired, so I'll tell you the name of it's translated in all languages, in Serbian as well. And it's a French author, quite racist, who speaks of the book appeared a little bit after this issue. I mean, after this law was enacted, and he speaks of a near future in France, so it's like futuristic, and it portrays France in which the president is of a Muslim. The president of the republic becomes shocking of a Muslim religion, a member of the Muslim Brotherhood. So it tells you how it can be, how that this is unfortunately present, even in societies where which by definition are inclusive, because this is the big distinction between the German concept of, when it comes to the Western Europe, to the German concept of the nationality and French concept of nationality before the Germany changed its law. So it was German concept was very exclusive, comprising that you could become a German only if you show that you have German ancestors. Whereas French concept of nationality was inclusive, considering that a nation is comprised of people living under the same laws. Basically, it's a territorial concept, whereas this one is ethnogenetic concept, a civic, territorial, ethnogenetic, and so this happens even in that kind of context, and from time to time, these movements are very strong. I fear that this piece of legislation, as well as the whole atmosphere which accompanied it, was also one of the reasons why the terrorist attacks followed up in 2015 with the Charlie Hebdo on the 7th of January, and then Bataclan in November 2015, and then in Nice 2016, and so on and so on and so forth. So it's that kind of unfortunately vicious circle. Also, to be clear, any person who forces, when you look at the French Criminal Code, any person who forces one or more other persons to conceal their face by threat, duress, coercion, abuse of authority or of office on account of their gender shall be liable to imprisonment for 1 year and a fine of 30,000 euros. And where the offense is committed against a minor, Michel Houellebecq is the name of that author. You can take a look at it, it's interesting. Where the offense is committed against a minor, such punishment shall be increased to 2 years imprisonment and a fine of 60,000 euros. So we see something that Dushanka was talking about, yeah? That when it is not a question of choice, when someone forces one or more other persons to conceal their face by threat, duress, coercion, abuse of authority or of office, on account of the gender, it is a punishable offense. So there is that perspective which has to be taken into account. And then let's look at how the question was decided by the French Constitutional Council, Conseil Constitutionnel, which, so after the adoption of the law, after it was adopted, it was the request that was made for the French Constitutional Council to decide about it, and the council. So it's like a French Constitutional Court, and it said sections 1 or 2. We read them of the statute referred for review are intended to respond to practices which until recently were of an exceptional nature, consisting in concealing the face in public places. The legislator was of the view that such practices might be dangerous for public safety and fail to comply with the minimum requirements of life in society. It is also found that those women who conceal their faces voluntarily or otherwise were placed in a situation of exclusion and inferiority that was patently incompatible with the constitutional principles of liberty and equality. So, what do you think about these arguments of the French Constitutional Council?
And she lives in Paris. She is of Senegalese nationality, but she lives there. And she works for a French government. And she has to explain and defend herself before some provisionary law.
Yes.
Place that she works.
Some tribunal.
She a lot of and some other colleagues. And one time it was very cold. She entered it because I know all of this because she was very upset, and then I know how this is implemented here. She entered the building with her scarf on because she forgot her cap. And it was very cold, and colleagues complained that she broke this because she's a Muslim, and then she had to explain everything because of the scarf. And I mean, burqa or no burqa, whatever she faces, a lot of difficulty there. And paradoxically, they are constantly trying to hire these Muslim people to work for the government for much lower prices. So they're kind of exploiting them and at the same time discriminating. So very nice. So it doesn't, I mean, from what I know from her experience, exclusion and inferiority are inevitable, whether or not they are wearing anything.
Okay.
That argument, zero.
Okay. Do you buy anything from here? Like, okay, public safety, we discussed it. The minimum requirements of life in society. What do you think about it as an argument? Yes, Martin.
I think it's just people trying to hold on to their idea of the ideal Western society and are not able to overcome their racist stereotypes. That's yeah.
Okay. Okay. Do you any account? Do you do you take into account the need for the people to communicate? Do you have impression that burqas and niqab prevent people from communicating?
if you are having prejudice and stereotypes towards the people who wear them, of course. But that's up to you, up to the person who is there. So
does the fact that we can all see each other, yeah, but the fact that we can't see anything, does that prevent us from communicating, like establishing relationships?
Of course. And also for people who don't hear that much, reading the lips is an important thing to communicate. When you put it on the scale, it's no argument.
When you said the scale, what did you mean?
When you compare both sides and the weight of their
there is usually they say above.
It's we have the right of expression and religious freedom, and then the argument of requirements of life in society, and then we look at both sides and then come to a conclusion. Yeah, but which one is more important in Serbia?
Okay, thank you. And then the council says it is also found that those women who conceal their faces, it says voluntarily or not, or otherwise, were placed in a situation of exclusion and inferiority. Yeah, but let's imagine that we are not in a let's say we are looking at the things in the most how should I say positive, optimistic way, disregarding other things. Does this place them in a situation of exclusion or inferiority? Do you see here elements of paternalism?
For them.
I'm sorry?
For them.
Yeah. It's that kind of thing. It's interesting. The French, there is this kind of, you can generally make a distinction between Europe and the United States. The concept of democracy and freedom of expression in the widest meaning of that word when it comes to expressing yourself. Generally, in the United States, the particular weight is given to the freedom of expression, to your right to do whatever you want as long as you don't harm anyone. Whereas in Europe, we have this little bit paternalistic approach, taking a distance at the higher position and deciding what is appropriate and what is not appropriate, with the best wishes. Yeah. Let's, as I said, let's think. Yes. Because there is, for example, another case of this court, French Constitutional Council, about the dwarfs. So the people of lower height by nature, and their engagement in circuses. And the French Constitutional Council said that it is not acceptable for them to be engaged in circuses because they're the object of fun, or they're the object of the way the others treat them in the circus. Sorry?
They don't know better.
Yeah. Sorry?
They don't know better. They don't know anything to do aside.
As if they don't know, as if they couldn't do anything better. That's one thing. The other thing is to, against I mean, this is also in line with the Kantian philosophy that you should look at every person as an aim and not just as an object. That you cannot objectify people. That you should look at them as a purpose and an aim. You know, not do to everyone else what you don't want to be done to you. There is that kind of, you know, as I said, paternalistic European approach, but which is sometimes good as well. So this looks like that kind of thing. I'm going to say something.
If we have these laws in place for both of the groups that you mentioned, and we have only that paternalistic view and whatever, but if you don't have gender equality set in place, you don't teach about possibilities, about what is about the possibility, but about choices, then this law, would be seen only as a coercion on that.
Yes.
So we can all be paternalistic towards any other being, but if we don't tackle the core of the problem, then we can do that.
Okay, I agree with you. We'll come back again to this argument. It's about education. It's about there is actually a resolution of the recommendation actually of the Council of Europe Parliamentary Assembly on gender equality and what it implies in terms of culture, like in terms of culture, but also in terms of education, how education should be organized, who should teach, what kind of educational programs we should have, what kind of language we should use, also media, how media should treat these issues, and etc., etc., and also lifelong learning programs for everyone who is occupying public positions, public servants, judges, parliamentarians, prosecutors, etc., etc., so that you can have this gender equality, as we said, not just formally, not just in on the paper, but in practice, effective. Okay, we'll come back to these arguments. Now, let's see how the court dealt with the issue. The court accepts that in adopting the impugned ban, the legislator sought to address questions of public safety within the meaning of the second paragraph of Article 8 and 9 of the Convention. The court is not convinced by the government's submission insofar as it concerns respect for equality between men and women. Okay, so I mean, at one point the court refers to public safety, and then it refers to equality between men and women, and then it doesn't develop actually the argument of public safety, for example. It goes into explanation of equality between men and women, which was exactly the argument raised by government. It doesn't doubt that, so the court says, it doesn't doubt that gender equality might rightly justify an interference with the exercise of certain rights and freedoms enshrined in the Convention. Thus, a state party which, in the name of gender equality, prohibits anyone from forcing women to conceal their face pursues an aim which corresponds to the protection of the rights and freedoms of others. So we saw that we mentioned that ground. So a state which, in the name of gender equality, prohibits anyone from forcing women to conceal their face pursues an aim which corresponds to the protection of rights and freedoms of others within the meaning of the second paragraph, Article 9 and 10 of the Convention. The court takes the view, however, that the state party cannot invoke gender equality in order to ban a practice that is defended by women. This is what you all said. So it's about protection of rights and freedoms of others, and then it's about others, not about the applicant. Such as the applicant, in the context of the exercise of the rights enshrined in those provisions, unless it were to be understood that individuals could be protected on the basis from the exercise of their own fundamental rights and freedoms. Okay? So the court said it was difficult to raise the argument of protection of rights and rights of others because it's not the applicant, it's the others. Okay, that's one position of the court. We can still continue questioning it. And then the court finds, by contrast, that under certain conditions, the respect for minimum requirements of life in society, referred to by the government, or of living together, can be linked to the legitimate aim of the protection of rights and freedoms of others. Which, this one?
Yeah, the living together part.
Mm-hmm. Okay, the living together concept, or how it squared it with protection of rights and freedoms of others?
Kind of both.
Okay, we'll go back to it. Let's finish it. The court takes into account the respondent state's point that the face plays an important role in social interaction. It can understand the view that individuals who are present in places open to all may not wish to see practices or attitudes developing there which would fundamentally call into question the possibility of open interpersonal relationships, which by virtue of an established consensus forms an indispensable element of community life within the society in question. The court is therefore able to accept that the barrier raised against others by way of concealing the face is perceived by the respondent state as breaching the right of others to live in a space of socialization, which makes living together easier. That being said, in view of the flexibility of the notion of living together and the resulting risk of abuse, the court must engage in a careful examination of the necessity of the impugned limitation. So the court actually adopted that concept of living together, which the French Constitutional Council raised, and it linked it to the legitimate aim of protection of rights and freedoms of others. In the French terminology, the French version is, it is called vouloir vivre ensemble, wishing to live together. So it implies that if you wish to live together, you have to live by my rules. On the other side, you can also say that there is no, or that it's at least difficult to have socialization without possibility to see each other. That concealment of the face prevents the socialization, prevents the integration, ability to establish contact, ability to engage, at least in a conversation, and maybe develop some further relationship out.
So niqab is preventing you to be a part of the society.
Yes. Yeah, this is yes. Niqab would prevent that person wearing it to become a part of the society. And again, the rest of the society cannot really engage with the person wearing niqab. Martin?
They have this high good of living together as a society. Under that, you could ban so many things.
Mm-hmm.
Is it common in France to use that kind of argumentation?
It does derive from a secular understanding of public place, and from the it's basically European way of looking at the thing. Like you have to but we can communicate only if we can see, faces or rest of the body, at least the face.
But when I look at it, when the argument is made that the protection of rights and freedoms of others is this sense of community.
Yeah, communitarianism.
And you also argue with that, for example, that far-right T-shirts should be banned.
Yeah.
Like public opinion, expressing your racist opinion publicly should be banned. And what is that?
Look, I mean, swastikas are banned.
Swastikas are banned for different reasons.
But you can, there are things where depending on what we said in the last class, depending on who is wearing, where, in what context, you may come to a situation where this can be considered as a hate speech. Far right, depending what exactly, and how much it hurts the given society.
The hate speech, but
like burning Quran, or like burning Bible, or like portraying Muhammad as a terrorist. These things. I mean, they haven't been banned. I have to say they haven't been banned. Again, that was the period exactly when we found those kind of cartoons, where Muhammad was. It came after the 11th September 2000, the attack on 2001, the attack on the Twin Towers, and all and that series of terrorist attacks which followed it. I mentioned it, 2004 in Madrid, 2005 in London. So and then you would have in Denmark. It's a Danish newspaper which published those cartoons where basically Mohammed was identified with the terrorism, like he was hiding the bombs under the guns and this kind of stuff, or he had the bomb as a turban. And then that was considered as a freedom of expression.
Exactly, and that's what I mean. Even though when it's not hate speech, but freedom of expression, you could also argue that it's still damaging the living together, the sense of community. So, I would say nearly equally as high as freedom of expression. So one of the highest goods we have to really live in a society and to ensure that everybody lives in society. Why can here they take this sense of community argument, which doesn't materialize the law, but take that as an argument, for example, with caricatures of Muhammad, or stuff like that, which is also highly damaging for community. I would say even more damaging. Or spreading of fake news from other people. Can't you apply the argument there?
First of all, we'll come back to the freedom of expression tomorrow. We'll talk about it tomorrow. I agree entirely with you that the court did not value exactly what you said. That identity is so much important for everyone who believes, everyone who's a believer, and to put a very vague concept of living together, not on an equal footing, but to give it more weight than to freedom of religion. Again, not to take into account the context, that there were no issues, which, of course, I mean, the question is really how much this is very important, how much this criminal code is applied. Because there is the issue that some women are forced to wear, that you have to take into account, which the court didn't sufficiently consider. It went into the argument of equality between men and women. Because, to be sure, those societies in which women wear burqas and niqabs are excessively patriarchal. And it's not a matter of choice. I mean, those societies where it comes from. It's not a matter of choice. It is just imposed to you from a very early age on, first as a hijab and then as a niqab. So that's okay, but this is how it is in those societies. And then you cannot also disregard the fact that that's a question for the evaluation and for examination when there is a problem, but there was no problem. There were no social conflicts coming out of it. But still you can ask yourself, even though there were no social conflicts, what about those silent women who cannot even speak? I mean, you know that in Afghanistan there was that ban as well to speak. I mean, and of course you can imagine that in a society where you have to wear, not the society imposes, but your inner society, family imposes you. You can imagine that you feel inferior in the wider society, and that you don't feel encouraged and empowered to speak out about it.
Wouldn't that be enough for the criminal code?
Yes, but provided that there is an effective, we actually do deal with this issue, and that we consider it, not to use the word that we attack the problem, that we actually take this problem into account and we try to solve it. Okay, so what I can take out of it is that there is equality between men and women as an argument. There is also the argument to prevent danger for the safety of persons and property, and combat identity fraud. So there are also issues of identity fraud can be associated with these type of practices. And that ensuring living together through the observance of the minimum of requirements of life in society, which is understood to be one facet of the rights and freedoms of others. So these are the possible grounds to for the legitimate aim of the blanket ban. So it's also interesting. It's a blanket ban of wearing full face, like no possibility to apply it in a proportionate way when it is needed. Okay, so a possible way out. Obviously, this is a case between communitarianism and paternalistic feminism on one side, or repressive tolerance on the other side. So, I mean, I suggest we work a little bit more, and then we finish earlier. So, Martin, when you said that communitarianism, you have to also take into account that you can look at it as a reaction of the community, by the community. But also that communitarianism may be regarded from the perspective of the smaller groups. And you can see that kind of behavior as a communitarian, because they are like separating themselves from the rest of the society. They have a like sectarian kind of behavior. And in France, there is this understanding that this is unacceptable. That in the public place we should all be equal, and to the extent that it is possible, look alike. And this is the reason why we'll come back to this issue tomorrow, when we tackle the problem of political rights. In France, it was when the equality quotas for women and men were introduced by the legislators, because we have probably mentioned in the other classes, and we have done it here as well. After the formal equality was introduced, we realized that, like in France, it was introduced in 1944, the right to the voting rights for women. And then it looks years and decades and no women in the parliament, or very few women in the parliament, and especially at the ministerial post. And then it was introduced, I think it was the time when Simone Weil was the Minister of Justice, they introduced quotas for women in the legislation. And then they took the case to the French Constitutional Council, and the Constitutional Council struck down this quota, finding it to be the violation of this universalistic French concept of equality, according to which we are all equal. There is no need to introduce quotas and any kind of preferences, and hence there are no minority rights. France is one of the rare countries, together with Belgium and Turkey, which did not ratify the European Convention on the rights of persons belonging to national minorities, and also a convention on minority and regional languages. So no possibility to use public language to use a minority language in a public place, and not in a public place, but use it in a public in the official documents or in official communication. So that is the French universalistic concept of equality, where we are all considered equal. There is no need to introduce any positive measures of positive discrimination or affirmative action. And then to overcome that issue, we had to change the constitution. So then the quotas, then the principle of equality was between men and women was explicitly introduced. I mean, the mere need to mention women, or separate the society between men and women was seen as something very much wrong. All coming back from the Middle Ages, when all European societies were stratified and defined according to their statuses. So, you were a son of fishermen, you will become a fisherman. You are you're a woman, you know what is your place in the household. So that kind of logic comes from that history where society was divided according to the statuses. And that was abolished by the French Revolution. The statuses were seen as something bad. And hence the need to not to recognize group rights. So the possibility for someone to use niqab or burqa, tolerating it would be seen as a group right, total group right. So just to have that kind of distinction of when we speak of communitarianism, what it usually communitarianism is referred to the inner, smaller minority groups. They're communitarianism. It can be also understood in a larger way. But here we see that kind of sort of paternalistic feminism approach. That you will not wear it because it is not appropriate for you. You're a woman and you should be equal, and as such, you don't need it. It's not good for you. It's a kind of paternalistic approach to how one should behave, or a repressive tolerance that we're gonna repress it because we cannot tolerate it, basically. So a very famous Swiss professor of human rights law said that burqa denies human dignity, specifically the right to individual personality by rendering individuality invisible. So there is that argument of human dignity on one side. And then Martha Nussbaum wrote a very good book where she examines different arguments in favor of banning whales and refutes all of them. And she uses this, she does it in a very convincing way, both looking at it from security, transparency, and civic friendship, from objectification, coercion, and health angle. So arguing that it is all these arguments that we use commonly, like civic friendship, tolerance, transparency, coercion, that this is something which is not at all convincing to ban away. My proposal is actually to take a look at conscientious objection principles, because we have that kind of situation where people are allowed to be exempted from, let's say, serving army or serving army under by using guns, and you have to look into there are protocols for establishing whether that case is a case of a sincere conscientious objection or it is a sort of a fraud. Whether someone just wants to avoid serving army under the guns. So there are, just like there is a criminal code which prohibits the coercion, like those who curse, who force the others to wear a case of a husband or a father, or maybe a brother who force their members of the family to behave that way. Because we also have to allow for women to have the choice. It is okay if this is really a matter of their choice, but if it is not okay if they are forced to do that, and if we don't, as a society, act accordingly to help them, to save them. So, since, as I said, it's a relatively limited number of those women who wear burqas and niqab in France, it is possible actually to, let's say, do a sort of investigation in that case and examine the context and examine the conditions, and why not allow exactly if that is their choice, which you have to take into account as a possibility. It's their choice. This is how they feel. This is how they consider they should express their religious freedom. But if it is not a matter of their choice, then they should be allowed to have that possibility to live in other ways. And also, of course, there are places where it is legitimately expected that you have to, unveil your face, like when there are security controls, or at situations where you are entering a bank, or So this is there should be public places where the rules should be drafted in such a way as to oblige those who want to enter them to open up their face for those purposes, and then allow them to conceal it in other places. Because also, as you said, Vishaka, I mean, if you don't allow them, if you just put it as a ban like this, then you actually prevent them even from having a minimum communication that they had by actually getting out of the house. And at least, although it's a one way, basically, they can see others, but others cannot see them. and they cannot. They definitely cannot establish contacts with others. That does prevent, but if it is someone's choice, that's the life of that person, and you have to respect it, as such. And that has to be exactly proven that this is their choice.
But then we have another philosophical question.
Yes.
Why is it their choice?
Yes, it's.
Came to the point that they choose that.
Yes, it is exactly. I mean, this is why you have to also provide for public education, provide for girls to and boys as well to follow the a public education where they will receive appropriate explanations as what are their rights and why it is important to use fully their rights and freedoms. Because exactly, you can also question how much it is their choice if it is predetermined by the family in which they were born. So it is already predetermined in a way.
Then it's not a choice. I mean, but
yes, but if they were educated in the for example in the system of the French public education, and they had that kind of possibility, of course, in the schools they cannot wear, as girls they cannot wear. But at least they had that information on and that kind of inclusion. For example, in France, when you delegate, when you choose what they call délégué de la classe, I don't know how it is in Germany, but in France, you have a boy and a girl who is the head of the class. As predstavnik udelsky zajednice. So I don't know if in Germany you have boy and a girl at the same time. Yeah, I don't know in Serbia how it is because I think it's just one person. This is a way to empower women, girls, to include them in the society and to give them equal opportunities. Of course, everything else related to the education, which implies providing appropriate information, which would further empower them. So, if someone followed, that curriculum, and after everything decided to live, provided again that economically that person could emancipate itself from its family and could, pursue its life differently, but still wants to wear it, then it's okay. And if it is not, then if that person didn't go through the French, through the public education system, then definitely she has to be further educated. Some additional education should be provided in order to, again, and of course, it's difficult to imagine that someone who has reached a certain age would change his previous beliefs. But I also know some friends who he took his mother who is Kuwaiti. He took his mother for medical purposes to Germany, and he said to his mother, "Now, mother, you can take it off, and you can do it if you want." And she said, "Yes, I want to do it." So she wanted it, and that is also possible. But again, it's interesting. It's in you feel free to do it in Germany, but not, of course. Okay, but we are speaking of of the European context and the European Convention in those countries which are under the jurisdiction of the Court of Human Rights. Okay, do you maybe have some more questions or comments? Good, thank you, and then see you tomorrow. Do you mind if we start tomorrow's class at 7 p.m.?
Until when?
I think it's 2 hours and a half. 9:30. Is it too late?
Yeah, that's on the morning.
Then let's stick to 6. Okay. We'll help you 6.
Okay.
Good. Okay. See you then tomorrow. 6, yes. Bye-bye. Sure. And goodbye to Saiful and Una.